Good afternoon, everyone. This is Vishal Sharma, your moderator for today's session. I am joined by Nishant Bartwal. Nishant is my co-moderator for today's session, and we have Prashanthi Reddy. Thank you. A bit about Prashanthi. Prashanthi is an alumni of University of Pennsylvania Law School from 1996, and she has been in the immigration field since 1997. So extensive experience. She has been admitted to the bar in New York, and she's a member of the American Immigration Lawyers Association and the New York Bar Association. Alongside this, she's also immigration co-chair for the Federation of Indian Associations and immigration chair for the National South Asian Bar Association. Currently, she's actively involved in pro bono legal work as well. On that note, I would welcome Prashanthi Reddy. And Prashanthi, the stage is yours.
Thank you very much, Vishal. Just want to let viewers know that I'm a little under the weather, so if I have to pause the camera or go offline for a minute, I hope you understand. So let's go to the next slide. I thought we would do just an AMA today with leaving the floor open to any questions that people have. But I just wanted to start with a quick update on the visa bulletin, since the session is for family immigration, employment-based, green cards, H1s, anything that you have a question about and that I can answer. If I cannot answer your question, I would happily answer it over an email once the session is over. And some questions may be too lengthy to answer or too specific to your fact scenario and may not be as interesting for the other audience. In that situation also, I might, want you to take it offline with me. So let's start with the October visa bulletin highlights. As you all know, in order to file a green card, you need to have a priority date that is current. The way you find out if your priority date is current or not is by going to travel.gov and you go to the visa bulletin. The visa bulletin is issued every month. And the new fiscal year for priority date starts October of every month. So that's why it's important. The October visa bulletin is important because we always see changes in the beginning of the year. So because new numbers become available in the beginning of each year, and the visa bulletin usually jumps ahead, and there are two tables that are usually used in a visa bulletin: dates for filing and final action date. The dates for filing is kind of a preemptive table where you can file your case in advance, and usually when the fiscal year starts, the dates for filing table is used, and that's what happened this October as well. So as of October, and the November visa bulletin also is out, which is not very different from October. It's exactly the same, in fact. So we'll talk about October. And in October, dates for filing table can be used. And we see that there's been quite a bit of recovery because in last year, as COVID receded and visa numbers became used more worldwide, we see that for the Indian nationals, with Indian and Chinese nationals that are always retrogressed because of the high volumes, there's not much excess visas like they were in the previous years during COVID 2020, 2021. So in 2022, 2023, we saw more use of the other visas, so there was not much trickle down for Indian nationals. So this year, it seems like it's back to normal pre-COVID levels. We have only 165,000 visas as opposed to 250 or 245,000 visas that we had during COVID because of the trickle-down effect. So while the visa bulletin shows improvement in the numbers, it doesn't show there is no way of filing new visas, meaning that the visa bulletin looks exactly the same as it looked last year at this time. So it's recovered back to last year this time because it retrogressed during the year as the numbers got over. But there are no new dates available. So the only people who will file are people who couldn't file last year, or filed but it got denied for some reason, etc., etc., or whose maybe I-140s got approved now. So for what various reasons, people who didn't file can now file. So just looking into the numbers, and USCIS and Department of State has said that there's a significant volumes of employment-based petitions that they have, and so this present volume that they already have is enough to cover the 165,000 new visas that are going to be given out this year. If you go to the next slide. So just looking at the numbers, EB2 and EB3. So as you know that there are two types of tables. The dates for filing table has not changed for EB2 and EB3 and remains at May 2012 and August 2012. EB1 has retrogressed for dates for filing from 2022 to 2019. So that's not good news. That's a 3-year retrogression. This is for the dates for filing table. For the final action date table, EB1 has moved up from January 2012 to 2017. EB2 has moved up as well by a year from 2011 to 2012, January. And EB3 has moved up as well significantly from 2009, January to May 2012, from 29 to 2012. So the final action dates are now closer to the dates for filing table, which is what USCIS wants every year. So I think that's all we have for slides. What do you have in the next slide? Then we can go to the Q&A. There you go. We can open up the session for Q&A now.
Please feel free to ask your questions now. I see it now. Thank you. So we have our first question for today. Prashanthi, the question is, what is the requirement for family immigration? It's a broad question, but I hope you'll be able to answer.
Yeah, I wish, Sia Chandra, you should be more specific with your question. What kind of family immigration are you looking at? But in general, family immigration means that you file an I-130 and a 485 if the person is in the country. Family-based petitions are available for immediate relatives, that is, spouses, children and parents of US citizens. And there are different types of family-based immigration, but the immediate relative petitions are current, while the other ones are not current, meaning that there's a wait time. So you can file for your brother and sister. Green card holders can file for their spouses. US citizens can file for their married or adult children, and that comes under a different category, and it's not immediate relative category. So there are various categories that you can file for. It's usually only permanent residents or US citizens that can file for their family. And the general requirement is that you have to show proof of relationship, to show that you qualify. You have to show financial ability to show that you're able to sponsor your relative. So you have to submit an affidavit of support and submit your last 3 years tax returns. So these are some of the requirements, and we can have a whole session on this. So, I'll stop there.
All right, thank you. Next question is, my H-1B registration is picked in the first lottery and now in the second lottery. I haven't filed in second lottery due to multiple registrations. Can I file now? Any RFEs on multiple registration from USCIS, which can be answerable? And what if I transfer the petition after approval to other consultancy? Any challenges? Okay,
So
so
he's
sorry, there was
basically
a correction. I just noticed there was a correction. I haven't filed in the first lottery due to multiple registrations. Can I file now?
okay. Um, so you can file if there's no multiple registrations in the second lottery. Um, Now, when we say multiple registrations, beneficiaries are allowed to file multiple registrations as long as each registration had a valid job offer behind it, and you're able to show that. So multiple registrations is only not allowed when companies are colluding together and filing as a group, registrations for the same person and then exchanging, candidates, etc. So that's not allowed. But multiple registrations by beneficiaries is allowed. So you certainly can file as long as, the scenario that I explained with reference to companies colluding with each other, that doesn't exist, then you can file for multiple registrations. And uh, also the question was, in the month of later, my H1. What was the other question? I think there was more than one question, right? What if
Yes,
I
yes.
transfer the petition after the approval to another
After the approval.
consultancy?
Yes.
Yes, you can transfer as long as you first work for this employer, you get payroll, then you can transfer to another employer after that. I hope that answers your question. But
Thank
I
you.
mean, if you're thinking that there was some multiple registrations issue in your second H1 also, and you think that somehow by transferring you might uh, not get into trouble, it's difficult to say. It depends on USCIS whether they allow you to transfer or they say that, to start off with, you're out of status. So that's something that really you will know only once you file the petition.
All right. So let's move on to the next question. I recently got H1B picked through different employer and I changed to new employer in the month of June and later my H1B was processed and approved. When would I be able to change to different employer if I wanted to? And if so, what documents are needed from employer? And would I get any RFEs for the H1B transfer through the new employer?
Uh, so the question is not clear. I recently got H1 picked through different employers. So I'm presuming that's a cap H1. And I changed to a new employer in the month of June and later so I'm presuming you changed employment, but your H1 is still only through the first employer. So he's asking when would I be able to change to different employer if I wanted to. And so you can't, so this is the story. If you have your H1 picked through employer A, but you're no longer working for them, then you cannot change your employer to employer B until your H1 gets approved and you start working for employer A, then you can file a transfer. If it's a cap case, in order to file a new H1, you'd have to go through the cap again. So the only situation in which you can change employers, if that is what you're asking me, because it's not clear, the only situation under which you can change employers is first work for employer A under the cap uh, subject H1 that got picked. And after getting a pay stub, which is after October 1st, is when you can start working. Then you can file a transfer to employer B, and then you're not subject to the cap as you already started working on your first H1. I think hopefully that's clear.
Okay, great, thanks. Again, a gentle reminder for everyone, and as we see, some of you have joined late. This is an question, so we assume the AMA session, so we assume you have questions for Prashanthi. So you can type in your questions in the chat window, and we'll be happy to pick. Thank you. Next question is, my sponsor My sponsor H1B company has been reported by USCIS for multiple filing and collusion. So what are the options I have left as I was unaware about this from employer, and how to avoid any future revocation as currently I am in US?
Hmm. So if you're presently on a H1, has the H1B, was it approved? Or it was not yet approved. If it wasn't approved, then it should be withdrawn and you should go back to your F1 status or whatever status you were in. But if it was already approved and you're on H1 status and they are revoking, oh yes, it was approved. Thanks. So, uh, so that means they're trying to revoke or they will revoke the present H1. That's what you're concerned about. You should immediately file for a transfer and see if that transfer gets approved, or you should file for a change of status, if possible, to another status, if you're able to, before your H1B approval gets revoked or withdrawn, if you are suspecting that that will happen.
All right.
And I think Namrata has the previous question that we were
It's a
answering about.
continuation. Yes.
Continuation. She says collusion has happened, but in the second lottery, but not in the first one. So if that is the case, then you should be okay because you're not filing the H1 through the first, um, through the companies that did something wrong. If there's no wrongdoing in the second, in the H1 that was picked through the second lottery, by that company, then you should be okay because, remember, as long as you're not doing what USCIS does not allow you to do, you should be fine. And I haven't seen RFEs recently by people who did not do any collusion, but by companies who did not do any collusion, even though beneficiaries might have. Companies clearly have not done the collusion and they have filed H1s. I have not seen any RFE so far. I've seen a lot of approvals. So let's see, wait and see what happens.
All right. So I hope that answers. Next question is someone who has an approved H1B from CAP and is based in India, can he transfer? Okay. Can he transfer to another employer and come to the US after the transfer has been approved?
So if you've gotten an approval under CAP, then the question is whether you are CAP exempt or not, even because you haven't started working on that H1. I think USCIS has said recently that has been approving cases recently and seems to be of the mind that such cases are CAP exempt, because the H1 was approved, even though they have not started working. So as long as October 1st, meaning that the H1 has become active, meaning it is after October 1st, after the start date of the approval, just to be safe, I would say that you can file another H1 consular processing since you're outside the country, and ask for the H1 to be approved based on the previously approved H1, stating that you're now CAP exempt. So you have to put a copy of the previously approved H1.
All right. The next question is, well, there are two questions. So the first one is, my name got picked in second lottery. My employer filed for LCA on October 2nd, and as per them, it's been approved by 10th October. Is it possible to verify the same from my end based on case, no or not, or it's only visible in employer's portal? So that's the first question, and there's a second question. I'll ask it.
So the first question, answer is no. You cannot, unfortunately, check whether the LCA is approved or not. For that, you have to have access to your employers or attorneys' portal, Labor Department portal, which most probably you don't have access to. So for you, it's not possible to check. So the only way to find out whether it's approved or not is ask for the approval.
Got it. And the next question is, my current work experience is 11 years, but unfortunately, my first two employers during 2009, 10, and 2013 to 2015 has shut down their business. However, I have their all documents like offer letters, salary stubs, and experience letters. In that situation, is it recommended to incorporate my first two employers' name in my petition slash resume, or I need to remove those employers' name? Interesting one.
You don't need to remove their names, and also you don't need to give their names either, because you don't need a resume when you're filing a H1. In fact, it is recommended not to have a resume, not to put your resume when you're filing the H1. But in some instances, you might need experience letters, especially if you don't have a bachelor's in computer science or a related field. An evaluation might need you might need to get an evaluation done, in which case, experience letters are important, and you just need to show 3 years of experience. If you already have a 4-year degree, and if it's not related, then they combine that with 3 years of experience and get you a work experience evaluation. So it depends on what your education is. Under those circumstances, we can decide whether experience is you need to show the experience letters or not, but resume is not needed at any point of time.
Okay, noted. Next question is, what will be the probability of picking up the lottery if applied through multiple consultancies? Uh, yeah, there are two questions, so I'll let you answer the first one.
uh, well, you are too late for lottery picking up, because the lottery picks have already been done. Second one was done, and there is a deadline to file the H1s that have been picked, which is the end of this month. So if you're asking for you're hoping for there'll be a third lottery, then could be that we don't know. The filing has been pretty low this year. It's difficult to say. You're asking me to predict something that no one can.
All right. Next question is from the same attendee. Uh, if I am selected from two consultancies, can I drop the one consultancy and file H1B for approval from another consultancy?
Yes, you can. You can choose which employer you file the H1 through, or you can file through both employers and decide which H1 to keep and which one to withdraw.
All right, great. Next question is, I have my family green card petition approved and all documents have been accepted on May 2nd. I have not yet received the interview date. What is the timeline for receiving an interview date?
It depends on what kind of petition you filed. But if you filed in May, then June, July, August, September, that's 4 months. It's difficult to say because the processing time is not uniform. I've seen cases get approved in 4 to 6 months, even before the AD is approved, the 485 is approved. I've seen sometimes it takes 10 to 12 months. If it's a family-based petition, it might, I mean, if it's a spousal-based petition, that means if you're married to a US citizen spouse, where they have to have an interview, then it might take longer. Other family-based petitions don't take as long, so it really depends, and hard for me to say uh, when to expect it, because the range is vast. It's ranges from 3 to 4 months to 12 to 18 months.
Noted. Next question is, I'm in California from May 2022. I carry total 15 years genuine experience in IT industry. Indian consultancies from whom I got selected H1B lottery this year, 2023, but they did not file my petition. Is there a reference on US companies who can sponsor H1B next year through your legal department? What's the right approach to get H1B sponsorships?
I cannot give you information as to which consulting company to approach to get a H1 because that's not what I do, and it's not correct also to do that. But with reference to, it's difficult to know whether that company is a bogus company or it's a genuine company, because I know that this year a lot of companies just started up their business, incorporated this year, and filed hundreds of registrations, thousands, and took money from the applicants and then just disappeared. So these are indications of a fraud company. I mean, look at the size of the company. That's an indication always. Um, if it's a new company and they're promising you the earth, then it's difficult for them to get you a job. If they have a confirmed job for you, then of course that shows that it's a genuine company if they already have a PO, SOW for you. So that's some things to ask the question the company, how many employees they have, what is their track record in the US, how many clients they have, and ask for proof of the same. And if they're asking you for money, then that might not be a good company to go with, because by law they're not supposed to. And that is indication that could be indication that there is some fraud involved and there is no real offer of employment there, or there's no real job available there.
Very important note that. Next question is, my H1B recently got approved through my new employer B, which I have recently changed from different employer A. So I have a question. What would I be able to move to employer A or C with same project to apply for H1B transfer? Also, from employer B, I already have 3 payrolls from July, August, and September. So am I eligible to change to employer A or C or end client through which my H1B got approved?
Did you understand any of that?
All I understood was A, B, and C.
Exactly. So I think next time we should try and get have a Q&A where they can actually talk to us. So that way they, sometimes it's difficult for them to write the facts out correctly. So we should think of doing that.
That's
But
perfectly
let's
fine.
try to decipher what he's saying. She's saying, Shilpa, got approved through my new employer B, which I have recently changed. So I have a question, would I be able to move to employer A or C with the same project? Well, yeah, that part, she's saying that I have a particular project and I want to keep transferring to a different employer using that same project. Well, that depends on uh, who holds that PO or SOW, right? Only they can offer you the job. The client obviously doesn't want to hire you on a H1, otherwise you would have joined the client directly. So you should, obviously then you have to go with the vendor. So now, so as if there is some connection between your employer and the vendor, say your company is acting as a sub vendor, then it's possible for you to keep the same job that you're working for and just and file a transfer of employer. Then she says, I already have 3 payrolls. So am I eligible to change? Yes, you're eligible to file for a transfer. As long as, whoever you're working for has a offer of employment and work available for you, and they're able to prove that.
All right. And Shilpa, I just noticed that you also dropped in another message suggesting that you tried to reach out to us for an appointment. What I would suggest is if you can drop us your email, we would be happy to reach out to you to set up an appointment, or you can fill out a web form that's available online. We'd be happy to reach out to you then as well. Thank you. Uh, and this is again a quick gentle reminder for everyone involved in this session. We still have about 15-20 minutes left for today's session. So if you have your questions, please type in all your question under the chat column, and please make sure that it's one single message that helps us answer your questions to the best of our abilities. Next question is, may I know the start date of the CAP new employment whose registration is expiring on October 31st, 2023? Can we put start date after October 31st, 2023?
That's a good question. Because as per USCIS, you have to put October 1st for the H1 approvals. And a few years before, when they had multiple lotteries, some of the H1s were filed in November because, the lottery, that's when the lottery happened, the second and third lottery. And they put November date, and then the USCIS denied those H1s, rather sent them back. And then there was a big hue and cry about it because, how can you put a date that has already passed? They said that you have to put October 1st as the date, and therefore we sent it back. But if the date of October 1st has already passed, how can you put a start date of October 1st was what people responded, and AILA got involved. And USCIS then kind of understood the point, and they again accepted those H1s. So in a nutshell, yes, you should put whatever date is the start date of employment. So you can put a date after October 31st on your H1 as a start date. It doesn't have to be October 1st. It has to be October 1st or later.
All right. Next question is there a chance of third lottery? If yes, when can we expect? But I'll let you answer that, and then there are a few other sub questions.
Thanks, Vishal. Yeah. So we don't know whether there'll be a third lottery or not. All I know is that the filing for the second lottery also hasn't been that great. A lot of people have received registration approvals in the lottery and have not filed. But whether it'll be enough to cover the people filing, whether it'll be enough to cover that 85,000 or not, difficult to say. So we should just wait and watch.
All right. Continuation to the same question was, can H4 work with I-797 approval if H1 be picked in third lottery or March 2024 or need to stamping?
Okay. What does that mean? Can H4 work? Can H4 work with I7 if H1 picked on in third lottery? I don't understand what that means, and I don't want to guess because
Yeah.
I'm just speculating here, and it may be incorrect.
Absolutely. So I think this is a very good example for everybody who tuned in to this session. Each of you have different cases, so we would be happy to schedule a one-on-one consultation so that we would be able to understand your case, your situation, and give you proper consultation.
It says further says, do we need to go for stamping again if H1 candidate changes his employer? So that we can answer that you don't need to go for stamping every time the H1 files a transfer. That visa is good for the duration as long as you remain on a H1.
Noted. Next question is, is this meeting only for H1B? I think it's the first time ever I'll be able to answer this question. No, it's an Ask Me Anything session. You can ask questions as you see fit. But again, answering that is something that we'll be just taking on a case-by-case basis. Can I ask some question regarding I-526? So yeah, if you have a question, feel free to ask. We will be able to either answer you here or take that offline. And then I'm just scrolling through. It's a continuation from a couple of the other attendees. What we would like to do is, for the interest of everyone's time, we would want to take fresh questions just to keep it simple. And then for some of the continuing questions, what we can do is we'd be happy to schedule a one-on-one session we'll share more details on that with you. While we wait for any fresh questions, Nishant, were there any questions offline that you may want to bring up?
Yes. So there was one question, Prashanthi. The question is, what is the effect of a H-1B denial on a I-485?
That's a good question, actually. So, if the H-1B is denied while the person has a 485 pending, uh, you basically then can switch from H1 to 485 status. And a pending 485 status allows you to work on EAD and allows you to travel on advance parole. So you'd just be changing your status from a non-immigrant to an intending immigrant. Um, and if the 485 were to get denied, then you fall out of status. So that's why a lot of people like to maintain their H1 while they're on 485.
Okay. Thank you for answering that question. The next question is, what if I have a DUI? How does it affect my I-485 approval?
Yeah, so DUI is driving under the influence, and that it's a crime. It's so if you commit, it depends on whether it's a misdemeanor or a felony. Uh, so if it's considered to be, and because I'm saying this is, we don't know this because it depends on which state you're in and what is the seriousness of the DUI. Was anyone hurt when you were driving, etc., etc. So if it's considered to be a felony, if the judge convicts you of a felony, then you have a problem with getting your green card, or we're talking about green card right now since the person is on a 485. So you'd have to file a waiver if you qualify. If you're not able to, then most probably the 485 will get denied. It'll also affect your non-immigrant status. If it's a misdemeanor, then it's possible that there is an exception for a petty offense exception, which says that if it's only one misdemeanor, then it'll be forgiven. So you can use the petty offense exception. But the problem with DUI is it's also a CMT, which is a crime against moral turpitude. They have this archaic uh, version of what is moral and immoral. So, crime against moral turpitude basically means that you're of bad moral character, and therefore they cannot approve your case. So, a DUI would also be a crime against moral turpitude. So, you'd have to figure that out as well as to see whether there are any exceptions to that. So, on the whole, don't drink and drive.
Got it. The next question is, what
I
happens
think
if I change?
I
Sorry.
think we have some additional questions online.
Yeah.
Yes, as we've mentioned, our priority would always be to answer as many questions of the audience who've joined us today. So the next question is, how many months will it take to get PERM ETA 9089 certified?
So that could take about a year and about 8 months to 10 months, 8 months to 12 months. And if there is an audit, then it could take slightly longer than a year.
All right. Next is, what is the minimum and maximum timeline for I-140 approval and I-140 process overview?
So the processing time for an I-140 luckily is very short if you file premium processing. So premium processing is allowed for an I-140. So they take 60 days nowadays for premium processing. 30 days for premium processing. So I-140s get approved pretty quickly unless there's an RFE and there's some issues and there is a delay on your side in responding to those issues. And the I-140 process overview. So he's asking me, how do you file an I-140? That's will take a long time to explain. But in general, you have three categories, EB1, EB2, and EB3. Depending on which category you file with, your priority date depends on that. And EB1 is better than EB2, and EB2 is better than EB3, where priority dates are concerned. EB1 is could be exceptional ability, could be multinational executive. So not many people qualify for an EB1. It's harder to qualify. EB2 is if you have a master's, and EB3 is if you have a bachelor's. Um, and in order to file for the I-140, you have to have, except in the EB1 category, in EB2 and EB3, you have to have an approved labor cert. And once that labor cert is approved, you can file the I-140. You have to show that your employer has the ability to pay, and you have to show that you have the required educational qualifications based on, the PERM requirement. And if all goes well, it will get approved.
All right. Next up, if I'm coming in L1A visa, my daughter age will be 17, start of February. We are planning to put her on 12th grade next year. Before completing 12th grade, she will be reaching her 18. Will she be in our dependent?
So the age is 21, not 18. And unfortunately, in you coming on an L1A, just an L1A doesn't help. You have to actually file an EB1 I-140. And once you file that I-140, it gets approved. The visa numbers for EB1, unfortunately, are not current. They were, but they're not now for Indian nationals. So the dates for filing, if you are able to qualify under dates for filing, and if that is current for you, and that's also not current because we saw the dates in the beginning of the session. But if you're able, if it does get current before she turns 21, and if you're able to file under dates for filing at least, then her age freezes once her 485 is filed, and hopefully that happens and she's able to get the green card along with you.
Okay. Next question is, I recently came to US on H-1B visa. My employer is not running my payroll. So can I transfer my H-1B within 60 days without pay slips from current employer?
Yes, you can, but generally 60 days grace period is if you are being hired and then laid off. It's not for people who never started working. So they ask for proof as to when you've been laid off. But you can definitely try to use the 60 days thing and use a combination of 60 days, and also say that you were not paid by your employer, produce an affidavit um, because it was not your fault, and do it under nunc pro tunc as well. So you can use both nunc pro tunc, humanitarian grounds, um, and 60 days grace as well.
All right. So since we don't have any new questions just yet, and it's almost inching the clock, Nishan, can you take us to the next slide? And while we do that, we have another question, so I'll try to answer that, or ask Prashanthi to answer that. I filed my petition with 4 different employers, and in lottery, it's been picked up by only one employer. But as USCIS's have my detail against my passport number, it might be a reason for rejection of my petition.
So again, to answer that question again, you're allowed to file multiple registrations. The only thing you have to keep in mind is when you're filing multiple registrations, you have to know that each registration has to have a valid job offer. If they're filing a frivolous registration, that's not allowed. So as long as there's a valid job offer and you're able to prove the same, multiple registrations by itself is not an issue.
Okay. Next question is, my I-145 was denied due to abandonment of I-145 application. USCIS stated that if I departed and left US, I assume, and hence denied my application, but I did not cross any borders. In such case, what should I do?
If I can provide evidence that I did not cross US borders, will my case be considered for reconsider my, okay, so it looks like he has a 485 file, maybe family based. And USCIS has wrongly denied it, saying that he has left the country maybe without advance parole, because if you're a family-based petition, if you have a family-based petition or employment-based, he says. So I'm not sure why USCIS would withdraw. Maybe he has been out of the country for a long time. Is that correct, Ravi? So it looks like it's an employment-based. I want, yeah.
Yeah.
And the 485 was denied due to abandonment of the 485. So in order to file a 485 or keep a 485 active, you have to show that you're residing in the US. You cannot, so you cannot leave the country for a period of 1 year, 2 years. And then if USCIS finds out that you have left, then they might deny it due to abandonment. But if you have never left and you're always in the US, I don't know why they would. Yeah, so there's some mistake on their part. So you should write back to them, file an appeal saying that you never left the US, and you can show your I-94. You can go to the I-94 website, right? And show all your entry and exit dates. That's proof enough that you've never left the US. So maybe they're confused or they're thinking that you're someone else. So just file an appeal within 30 days.
Interesting one. Nishan, can we move to the next slide, please? So while we were able to answer most of your questions, if not all of it, we can certainly help with your application and with further consultation. We have. So on that note, we would be wrapping up the session.